Well, hello and welcome to a post oral argument response here. As you can tell, I'm still dressed up in my court court attire. I just finished the oral arguments a few seconds ago. Psychologist in a legal proceeding. Oh my goodness. So the motion in limine for the complainant was granted relative to the testimony of Dr. Strom. However, I have a letter from Dr. Strom. He's a fact witness, and I have a letter from him that I consulted with him, and I'll introduce that, his involvement during my testimony, and then the evidence to support that as an exhibit. And so that's still pending. He's not essential to the case. He's just showing the escalating actions that I took. Then the second part about parental alienation, the administrative law judge ruled that he doesn't want any testimony about the validity of parental alienation syndrome. I don't actually either. That's not the issue. It is in violation of 2.04, 9.01, and then the complainants are in violation of 2.01. So that's just fact. It's not part of the DSM, it's a fact. But then as my motion in limine, the judge did not grant the judicial notice that it's not in the DSM-5. He denied my motion in limine. And then he's not going to establish 2.04 and 9.05, 9.01 evidentiary standards, or require citations, or limit testimony on or use of parental alienation constructs, because he says that's discretionary, and that's something he would do anyway during the hearing. Nevertheless, I read an objection into the record to preserve the record for possible appeal on the denial of my motion in limine of establishing standards for evidentiary admission, and preventing or acknowledging the violations of ethical standards associated with that construct. We also made argument that the state is making a very limited argument that my actions were in violation of the collegiality standards, and I entered into the record that my actions those actions are in conflict with the the protective standards of 1.04 and 1.05 that are triggered by ethical violations. And that's why it becomes important that PA and PAS do not meet the 2.04 and 9.01 evidentiary standards, because then that triggers the 1.04 and 1.05 protective standards. And when there are conflicts, so the state and prosecution will frame my actions within the context of the collegiality standards, basically the three series, and land on the harm 3.04 of reputational damage. Meanwhile, I will be framing my conduct within the protective standards of the APA Ethics Code 1.04 and 1.05, and the harm that I will be establishing from that perspective will be harm to the children in the family courts, harm to the parents in the family courts, and harm to the court's decision making. And Principle A of the APA Ethics Code says when there are conflicting ethical obligations, that the principle to apply is avoiding or minimizing harm. And so the state will first present its framing of my conduct within the collegiality standards, and the harm being the reputational damage to Doctors Bernay and Lorandos. I will be presenting the 1.04 1.05 framing of my conduct, which relies on violations of 2.04, 9.01, and 2.01. Those are the ethical violations that then trigger the protective standards. The protective standards are only triggered when there's ethical violations. Okay, so that's a set that I'm in. Now, when we reach the 1.05 standards, that's going to involve a particular phrase that I am required to psychologists take further action. That's an affirmative duty. I have to take further action appropriate to the situation. And so what's appropriate to the situation? That will be the admission of the context, the institutional capture, the institutional betrayal. The other evidence will be relative to my escalating obligations under 1.04 and 1.05 that I've been taking across the entire 15 years in the family courts. And so while the actions early on are not relevant to the later criticisms of them on the posting from a collegiality application, they are directly relevant to the 1.04 and 1.05 that require an escalating series of actions and then appropriate to the situation. Was there any other avenue that I could prevent the harm to being caused to the children and the parents and the courts? That would then lead me into having to make public criticism to the same audience that Doctors Bernay and Lorandos are spreading their psychiatric and psychological misinformation to the public and to the courts. So it's going to get into all sorts of stuff. Now, my license is on the line here, and I like the judge. I think the judge seems a reasonable person, and as I said before, I have a lot of respect for the court and the judiciary, and I understand the rulings. I don't necessarily agree with all of them. I think it's clear that the PA and PAS do not meet, are not in any diagnostic system, and are in violation of don't meet 2.04 and 9.01 requirements. But that will be something that the judge will allow me to present during my testimony. Now, the state anticipates that they will be getting, being finished with their presentation of their case by Tuesday afternoon. From what I understand, they anticipate putting on their analysts on Monday, and then they will put on Dr. Burnett, what is it, on Monday afternoon. Okay. And then Tuesday, they're going to put on, Tuesday morning, they will put on their expert testimony, at which point Tuesday afternoon, the defense will begin its presentation of its case. And the defense is basically going to be my testimony, my direct testimony about the situation. So that's likely to be extensive. So I'll be talking about that on Tuesday afternoon after lunch, most likely, unless some of the cross-examination of Doctors Burnett and Lorandos it gets extended. Which cross-examination, which might be possible. We'll see where that goes. But then the defense will move into the next day, the Monday, Tuesday, the Wednesday will be the defense and the arguments, closing arguments. Now I'm going to have a 15-minute opening argument to begin with, and then a closing argument at the end as well. So that's the basic structure of the case. Also, a discovery cutoff was set for this coming December 23rd, And let me see about something here. Okay, so I just read an email from Peter Knutson. So I will be offering, currently I'm offering Dorsey Pruder as an eyewitness to meetings with Dr. Burnett. And I will, just contacted a second eyewitness to the Venice meeting, Venice, Italy meeting, Peter Knutson. And along with Dorsey, we're both at that meeting. He's a parent advocate in Europe. And I will be submitting his name to the witness list as an eyewitness to that meeting, pursuant to the upcoming discovery. So I'll be doing that. What's today? Thursday? No, today's Friday. So I'll be doing that on Monday, adding him to the witness list. I don't anticipate difficulties with either one of those because they are eyewitnesses to direct meetings I had with Dr. Burnett in regarding my concerns and corrective efforts at corrective actions. So that's the current status of things. I want to point something out. This tie, of all the ties I picked up, this is my dad's tie. My dad was an attorney, worked in the court system, and it's the only tie I recovered from all his stuff over all these years. And so I thought I'd wear it in kind of his honor. Hey, Dad, I'm like representing his counsel, carrying on the family tradition. I like these old ties because they're so thin and everything. Oh my goodness! And he was kind of wild back in the 1950s for wearing these wild things instead of the typical uniform. But with that, I just wanted to sort of come on and share with everybody what's happening. The fundamental framing of the case is that the state is applying one set of ethical standards, the collegiality standards, and saying I'm violated those. I'm arguing that there are conflicting obligations within the APA Ethics Code, and that I have 1.04 and 1.05 obligations relative to the violation of 2.04 and 9.01 and 2.01, and that within that context of conflicting ethical violations, that my actions represented further action appropriate to the situation. And so we're on. Here we go. My career's on the line, and if I'm removed from the family courts, you get your parental alienation experts and forensic custody evaluators. Good luck to you. And I'll move on to other aspects of career like writing books and doing other things. If I'm not removed from the family courts, then we get some changes in court reforms and start protecting children from child abuse and parents from spousal abuse, and providing the courts with appropriate levels of professional information. Now, another thing that the administrative law judge noted is that the hearings are public. So they are public hearings, and he noted that there have been people requesting to participate or to watch. He requests that you turn off your microphones and screen so that you don't disrupt the process, but the public and any media and any legislative assistants or analysts can all observe these hearings. And I would offer that probably the most valuable time will be the cross-examination or direct examination, cross-examination of Doctors Burnett and Larandos on Monday afternoon, potentially extending into Tuesday morning, and that my testimony and defense beginning on Tuesday afternoon and moving into Wednesday will be probably the most interesting There will be a court reporter, so there will be a public transcript of everything. The administrative law judge requested or requires that there be no recording of the proceedings, and so no audio or video recording of the proceedings is allowed. Let me see, anything else? Okay, no. So I'm going to, I have a couple of clients later this afternoon, so I'm going to kind of recover from all the stress and anxiety of trying to do this. And we'll see you tomorrow with my next daily update on the situation. So good luck, everybody, and take care out there. And I'll be heading off to the rest of my day and fortunately into